Good afternoon and welcome once again to Fired Up. I'm your host for the show, Bob Irwin. We are broadcasting live from the studios of the American Guns and Glory Network here in Las Vegas, Nevada. This show is about guns, related political issues, and self-defense. Fired Up is on our website, Fired Up with Bob Irwin. New show is posted every Thursday around 5 p.m. Pacific time. New shows also appear on YouTube and numerous other media. The audio feed is rebroadcast for radio listeners Saturday at noon on the Nevada Talk Network. Check out KELY1230.com for a station in your area. Questions and comments can be sent by email to bob@firedupmail.com or leave a message on my home office recorder, which is 702-257-1060. If you leave contact information, we will respond by email, text, or telephone. Questions directed to our guests will be forwarded to our guests. In the case of tonight's guest, he'll put it on the show at the same time. There are several hundred defensive uses of firearms every week in the United States, rarely covered by our mainstream media. So we always present some of those for our listeners' education. Some are good shooting, some are bad shooting, some are questionable. They're all picked out. I picked them out for reference to if you own a firearm or you keep a firearm in your home, you carry one concealed, what you can do and what you can't do. You need to understand that Fired Up is a nationwide show. Individual incidents are generally adjudicated under local law. The results might not apply to you. The advice we give on this show might not apply to you in your area. So what we're doing is giving you information designed to keep you out of jail and hopefully from losing a civil lawsuit and thereby losing your house or whatever. These are complicated issues. If you are already involved in an incident of some sort, you can contact myself or my guest through our websites, and we will direct you to an attorney in the area, the local area where you live. Obviously, when we're talking about shooting incidents, the law that would apply in Nevada is different than California. Fortunately, my guest does both of those. But if it's in Wyoming, it's certainly going to be different than New York City, et cetera, et cetera. Local law prevails. So, my guest today is California and Nevada attorney Donald Green. Welcome back again, Don.
Thank you, Bob.
Nice time.
No, thank you.
We are, if you'd give us a little bit of your background for any new listeners,
Sure.
We'll be right there.
Sure. My name is Don Green, and I'm a lawyer in California and Nevada, principally based in Nevada. And I've been a lawyer for 35 years, with the principal emphasis of my practice being firearms and related issues, business litigation, and criminal defense. As to firearms, we work in just about every conceivable area with firearms, from alcohol, tobacco, and firearms criminal investigations, FBI investigations. We also represent clients who are targets of investigations by the sale or possession or transfer of weapons. And we also handle FBI appeals of denials of firearms for various reasons in various states. People who are living in Nevada and may have some problems in the past which have been expunged or otherwise pardoned, and something's not clear in the record with the FBI. We also assist those people who otherwise would qualify for like concealed weapons permits when their concealed weapons permits are denied or revoked or suspended in some fashion by the Las Vegas Metropolitan Police through the Office of the Sheriff, which is the issuing authority. You can reach me directly on my private cellular at 702-409-8239. And that cellular is on 24 hours a day, 7 days a week. Thank you, Bob.
All right. Glad to have you on the show again.
Thank you.
This first story comes from Raleigh, actually North Raleigh, North Carolina, from the News and Observer, a newspaper there. This incident took place on the 24th of this month. We are broadcasting on the 27th. So there's a lot of lot of stuff here, but this is, so we don't have a lot of the information that's going to eventually come out in this case, but it presents some interesting ideas. So I just had to have this case up when I had Don on the show. A Wake County grand jury on Monday returned returned a indictment against a 41-year-old convenience store employee in the fatal shooting of a robbery suspect. Oh, there we go. My monitors come up. Officers said the employee and the robber exchanged gunfire during the robbery. The robber was struck and had a gunshot wound to his leg. There were no other injuries reported. Now, this was late in the afternoon. There was no time given, but anyway, at 10:30 p.m. on July 14th, same day, police discovered a body in the 4200 block of Waterbury Road. It turned out this was the guy who robbed the convenience store. 2 days later, on July 16th, investigators learned that it was the suspect in the robbery that happened 2 nights ago, and he was found in the mini mart in the 5500 block of Old Wake Forest Road. The convenience store is less than 3 miles from where the body was located. Months have passed since this July 14 shooting. Wake County District Attorney, her name is Lauren Freeman, did not detail what prompted her office to present the case to the grand jury at this time. That's coming up. The clerk is now charged with voluntary manslaughter for the fatal shooting of the 21-year-old robber. The clerk was taken into custody at the convenience store on Old Wake Forest Road where the midsummer shooting took place. Detectives continued their investigation and worked in consultation with the district attorney's office. The district attorney presented the investigative findings to a grand jury on Monday morning, resulting in the charges being filed. There's a little bit of supposition here because this is so new and there's so little details listed. But apparently, what happened is the robber and the clerk got into a gunfight. The police reports say the robber was armed, and we know the clerk was hit. And he fired back. So the clerk told the cops the bad guy got away, although he did state possibly the guy was wounded. It appears that instead of calling medical help for the wounded robber, the clerk dumped the body and lied to investigators about it for some reason. Clearly, from the face of it, this is arguably a self-defense shooting, so why would you mislead the police investigators about what happened? I am just... One, we need to find out from Don how the grand jury charges him with a manslaughter case. And hopefully, if I can follow up on the story, if there's more stuff printed after the thing goes to trial, but we may be looking at a year down the line before it happens, so there's maybe a while. But why in the world, if you're in a self-defense gunfight, would you lie, move the body, dump it, and then lie to the police and say the guy ran away? It makes no sense to me. But anyway, here we go.
If, as you say, the clerk at the convenience store did shoot the victim, now deceased, and move the body, that's an independent crime. That would not be involuntary manslaughter. We're missing a lot in this case.
Yeah.
What we don't know is why the district attorney there in North Carolina took the case to the grand jury. Generally, a district attorney has the discretion to have the case proceed through the Justice Court in Nevada and the lower superior courts in California for what's known as a preliminary hearing, where the judge does not find you guilty, but the judge only determines if there's enough evidence to send the case to a higher court for a jury trial. And you plead not guilty and get your trial. On the other hand, in Nevada and in California, the grand jury is available to the district attorney to present a case In Nevada and California, the grand jury meets in secret. You may know about that through you're being served with the court paper, or your attorney is served with the court paper stating that we're going to take you to the grand jury. This is the general case, except in Nevada, those particularly egregious crimes, murder, arson, robbery, sexual assault, kidnapping, racketeering, large drug conspiracies, because of the nature of those cases and the probability that if the defendants know beforehand that they're going to be indicted, those defendants will probably flee the jurisdiction or flee the country. So that's the reason why the district attorney might try to get a different level of a grand jury. What happens at a grand jury? At a grand jury, the witness testifies on direct examination by the district attorney. In Nevada and California, in Nevada in particular, there is no right for the attorney to ask questions of witnesses before a grand jury. In federal grand jury, it's impossible. It's not even available. So you're left with a one-sided proceeding which has been upheld by the Nevada Supreme Court and which has been part of the Nevada revised statutes for over 100 years. Nevada becoming a state on October 31st, 1864. So for well over 100 years, we've had a grand jury in some form. The grand jury must hear evidence of the best nature and of the best kind. So you cannot use otherwise inadmissible evidence at a grand jury proceeding, such as certain types of hearsay. There are other types of evidentiary tools which the district attorney must avoid. Character assassinations, irrelevant, highly inflammatory or irrelevant material. But there are some grand jury proceedings which can be challenged. You challenge them in district court in Nevada by a writ of habeas corpus, which now, believe it or not, the clerk of the 8th Judicial District Court, in his infinite wisdom, has said, we're now going to file all writs of habeas corpus as independent civil proceedings. So you get a case number in civil, you get an assignment to the judge, and it's totally confusing because most of the habeas petitions usually go to the judge to whom the case is assigned. It's going to create some confusion. It is creating some confusion. I don't know the rationale, other than in federal court, when you file for like post-conviction relief, although it's an independent civil case with its own civil docket case number, it is assigned to the judge who actually heard your case, unless that judge is under a disability or is no longer a judge. It gets assigned to whoever sentenced you 20 years ago, if that judge is still an active judge. So bottom line, the grand jury hears this evidence. The grand jury is presented with an indictment or proposed indictment by the district attorney. The district attorney says the members of the grand jury shall vote. The DA goes out in the hallway. The clerk comes out and says, Mr. District Attorney, we have a return on the indictment. And the foreman of the grand jury will say, Mr. District Attorney, we have issued a true bill, B-I-L-L, which charges the defendants with involuntary manslaughter, discharge of a firearm, disposing of a body, disposing of a corpse, committing a crime which was otherwise legal, but in an illegal manner. And that would be to shoot the guy and dump the body 3 miles down the road. Because at the time that you shot him, there may have been justification, but your subsequent taking the body 3 miles down the road and dumping him, if that's what the case was, and if it results in death, it is an act which is not murder, but it's an act which you did and it caused the death. So that would be the grand jury. There may be some political factors we don't know about. Your dog and my dog literally can be indicted by the Clark County Grand Jury for some form. But this is a good story for us to follow up for your readers, because they need to, your listeners, excuse me. your readers, I mean, your viewers, because I've been talking all day about some people reading some articles. Your viewers and your listeners need to be really keen on the fact that you might not get a preliminary hearing in your otherwise defensive shooting. Your case might go in the discretion of the DA directly to the grand jury. You're going to be indicted. You're going to spend a lot of money unless you've got carry concealed insurance, and you're going to be going straight to trial, and you pass go and don't collect your $200. So your listeners and viewers need to be aware of that.
That explains, which I never actually inquired to find out what happened. There was a client that was to be defended on a shooting case, and it was a questionable, the ballistics were questionable, this and that, and the defense counsel wanted me to testify as an expert before the grand jury. And the DA's office initially agreed, and then on further thought, they went, my God, we can't do that. We can't present, because look at the precedent we're going to set if we let an expert testify for the defense at a grand jury. And the case was based on whether the gun worked or not. It was well within my bounds to testify. But the venue was absolutely wrong. And I could see, what would happen. Grand juries would become trials.
That's correct.
With both, all of this going on. And the thing would never get to court. And nobody could afford it. I mean,
Yes.
How could you afford to defend yourself? And you're looking at 3 trials now.
Possibly. You can present, in Nevada, you can present evidence to the district attorney on notice. You submit your paperwork and say, notice of defense request to present this evidence. For example, you were in Rome receiving Holy Communion from Pope Francis, and almost all those are videotaped, and they sell you the videotape, and it actually shows the Pope putting the Eucharist in your mouth. You can show that as alibi that I could not have been in Las Vegas at the time shooting someone. Or you can present perhaps some financial records to show that you were not embezzling these funds, that in fact you were the mistress of the guy who owned the casino, and you had a power of attorney, and within your job description, you could take certain funds for personal use. You might want to present that in an embezzlement case. You may want to present certain other types of evidence, but it is not incumbent upon the district attorney to rule upon your request. He's going to say, well, this is not relevant, and then you may end up in some court proceedings in the future.
This system is way too complicated. When we talk about these cases, you realize how involved this gets regular listeners to what you see on TV, and you think you can go defend yourself and, because you're right, everything will work out fine. If you don't need to shoot this guy, don't shoot him.
Correct.
We're going to break for a brief commercial just for a second here, and we'll be back in just a few.
My name is Jerry Creed, and I'm a gun trust attorney. If you want to own an NFA firearm, a gun trust is a great way to own it because it allows multiple people to lawfully possess a firearm instead of just a single individual. I have reviewed lots of gun trusts, and I have found they often don't include the forms you need to bring people on as trustees and remove them as trustees. In addition, a gun trust will save you the cost of probate and avoid probate, and it can protect your executor and family members. There isn't an element of intent in these laws that affect the NFA firearm possession. So it doesn't matter if your wife didn't intend to sell the gun, at a garage sale or yard sale, or your daughter didn't intend to drive the car with the silencer in the trunk. A gun trust is a great way to protect your family members and friends and share in the fun and pleasure of owning NFA weapons. If you want a gun trust done right, remember to trust Jerry.
Hi, I'm Bob Irwin, and I get to do my own commercial. The short version is I've had 50 years experience in firearms, firearm repair, firearm design, 30,000 CCW holders I've personally taught, 20,000 security officers, etc. Taught in 28 police academies, firearms and use force. I've also appeared more than 200 times in gun-related cases in federal, state, and local court. I wrote this book, The Reality of Armed Self-Defense, because it answers virtually all the questions that I get every time I talk to people, answers questions that come in the emails. It will tell you what you need to know to keep yourself out of prison if you get involved in a self-defense shooting case, keep from losing your house in a civil lawsuit. There are lots of things I've learned over these years and watched people make a lot of mistakes. This book will save you a lot. If you purchase one, read through it, I'm sure you will find it enlightening. And it'll save me a lot of time on these shows trying to explain to people what they did wrong and what they shouldn't have done and so forth and so on. So you can buy it by sending me the funds at the address below, bob@firedupmail.com, or leave a message on my phone number there, which is 702-257-1060. I will return your calls and tell you where to mail the money and so forth and so on. They're available on my website also, which is attached to this regular show. Cost is $15. I said add for postage if you live outside the immediate 50 states, and I will get it to you first class mail. Thank you for listening. This book will save you a lot of hassle. Thanks. We are back. This next story, this is from thestate.com, 9/21 in Columbia, or September 21st in Columbia, South Carolina. Columbia Police Department report, an employee at the China Kitchen shot a man who police believe was trying to rob the restaurant around 11 p.m. The police arrived at the scene of on Forest Drive and Two-Notch Road, I can say that. The restaurant around 11 p.m. They found the suspect on the ground. He had been shot in the upper torso. He was wearing all black and had covering over his face. Employees told police the man entered the restaurant with a gun, demanded money from the register, and one employee tried to grab the gun away from the man. They fought over the gun. Another employee then shot the suspect. The second employee was carrying his own gun. The would-be robber was transported to a nearby Providence hospital where he was pronounced dead. The worker will not be charged, and the police are calling the case self-defense. The identity of the alleged robber has not been released, and the Richland County Coroner's Office will wait for the name of the deceased to notify next of kin. This is a great case, a courageous employee who attempted to take the gun from the armed robber. No question that this case is legal self-defense of others. It's a lot easier, though, to bring your own firearm to the gunfight rather than try to borrow his. The third-party shooting is, I think, on this case, clearly self-defense. I expect, Don, you will agree with that it's
Yes.
pretty good. The guy's wearing a mask. He's trying to rob the place. Bang, bang. My point of running this one was it's a lot easier to carry your own gun. We get a lot of these cases. I've seen lots of these where you try to take the gun away from the bad guy, and that becomes unproblematic if you're firing as he's pulling away, and we get all these timing things and so on and so on. While they're fighting over the gun and this guy fires, slam dunk. Always carry your gun. You never know when you're going to need it.
Right. In this case, again, stress the time of night, 11 p.m. Every example you've had today and last week was late at night, early in the morning. There was one example, 7:25 p.m. in Minnesota about a week ago, so it was kind of getting there. But here, the suspect, as you point out, was wearing all black and covering his face. He was not collecting for the Girl Scouts or the Red Cross. His entry into the restaurant with the gun establishes a point for specific intent to commit the crime of burglary, and then to establish part of his intent to commit another crime of the robbery was that, he was doing this to rob, presented the weapon, a fight ensues between employee 1 and the robber. Employee 2 gets involved, and there is the shot fired. Now, second employee is carrying his own weapon, presumably because the police are not charging him with murder, manslaughter, or some kind of involuntary manslaughter. Presumably, the shopkeeper was carrying the gun legally, either concealed or open. And I'm not sure if South Carolina is an open carry state. Nevada accepts South Carolina's CCWs, but South Carolina does not accept South Carolina for whatever reason. So
they don't accept Nevada.
right, they don't accept Nevada. So I cannot speak for how this man was carrying his weapon. But in Nevada, if this is a case which is presented to the district attorney's office, I agree it's probably going to be self-defense and a good shooting. It obviously is in South Carolina by virtue of the news report. California is 50%. Because I know it sounds kind of strange, what is the great bodily harm or injury to employee number 2? He sees that there is a fight over a weapon. The weapon has not been discharged. The second employee shot the victim. Victim is pronounced dead. So if you're in Los Angeles County, you have a chance of being arrested and detained on a charge of murder, open murder, first-degree murder, second-degree murder, manslaughter, or involuntary manslaughter. There's a 50% chance that you might not be charged. But perhaps you've got a new deputy district attorney who is politically affiliated with anti-gun groups, or he wants to make his name known. He could very well charge this man. And I think, but I'm not positive, that a case which you handled, Bob, as an expert was similar but not identical. Was that the marijuana shop shooting?
Yeah. Yeah, the head shop shooting, yeah. And you look at this case and you change just a couple of minor things that the defending guy wouldn't have known. Let's say it turns out this is a 15-year-old. Or it turns out that it was a BB gun or a fake gun, which he didn't know. So it's a reasonable shooting, but then you've got a dead 15-year-old. You've got, there was no danger, even though he tried to pretend there was danger. That was the smoke shop case. Just changing a couple of those things makes this whole case.
Yes.
There have never been 2 shootings in the history of the United States that are the same. They're all different. It's why God made lawyers. Don't
Thank you.
assume that I'll eat that with some of my followers as a God made lawyers. But things are different every time. Don't talk until you talk to a lawyer. Give them your gun or set it down or whatever and just say, I work here, or this is my house. I don't know the guy. My gun's over there in the drawer. I'd like to talk to an attorney before I make a statement. Fine. And if they keep talking, you just say, want lawyer now.
Yes.
Right?
Unequivocal, state it unequivocally. I want a lawyer. End of story.
Yeah, we've had cases where we've looked at where the guy has said to the officers, do you think I need a lawyer?
It's not good enough.
That is not asking for a lawyer. The officer's going to say, well, it's kind of up to you, but it might make you look guilty if you ask for one. You look guilty already. There's a smoking gun and a dead guy on the floor. You need a lawyer. I want to thank you all for watching. We had one more case. We'll pick it up next time because it was a really good, clean, wonderful shooting. Those do happen. I just found one I just had to run, but we're out of time. Check our website, firedupwithboberwin.com. Please patronize our sponsors, especially the guy who was selling the books. We'll be back next Thursday on YouTube and the American Guns and Glory Network. Don't forget to check out our radio feed on the KELY1230.com. It's on 18 stations now around Nevada, I believe, AM and FM, all mixed up. Every town in Nevada with 7 people gets this radio show. When you see us on the internet, hit the subscribe button. It'll be somewhere on the website that you're seeing us on. We're on all over the place that I'm not even aware of until people call me. Say, I saw you on blip, and I didn't know you were on. It happens on a daily basis. So hit subscribe, and they will send you the shows automatically as soon as we're done with them on Thursdays. Thanks for watching. Thank
you.
you again, Dean.
Thank
Don?
you.
Dean?
Don, thank you so much, Bob. Always a pleasure.